So, first of all, welcome to those joining us for Israel and the ICC, the court, the threat, and what we do now, an Israel Law and Liberty Forum conversation with three international law experts joining us tonight from the US, UK, and Israel. My name is Elena Meisel, and I am the executive director of the forum, which is a nonpartisan Israeli educational initiative founded to cultivate conservative leadership and deeper conversations within Israel's legal profession. Since the atrocities of October 7th and the start of Israel's defensive war, we have expanded our work to include discussions and publications on issues of international law and the law of armed conflict. So I invite you to stay tuned for future events of this nature. I'll say a few words of background about tonight's event, but as I said, I want to move quickly to our speakers, who I'll first introduce. So with us tonight is Professor Orde Kittrie, a senior fellow at FDD and a law professor at Arizona State University's Sandra Day O'Connor College of Law. He is a leading expert on international law and policy, particularly as it relates to the Middle East. He is the author of Lawfare, Law as a Weapon of War, which describes how and why law is becoming an increasingly powerful and prevalent weapon of war used by states, NGOs, and individuals. He served as a State Department official for 11 years, during which he was decorated for excellence. Professor Avi Bell is a professor at Bar-Ilan University's Faculty of Law and at the University of San Diego School of Law. He is among the world's leading scholars of property and intellectual property law, international law, and the economic analysis of law. He is a former president of the Israel Law and Economics Association, a former visiting fellow at Harvard Law School, among other prestigious appointments, and he currently serves as a senior fellow at the Kohelet Policy Forum and as dean of the forum's summer seminar in law and democracy. Prior to entering academia, he clerked for Justice Mishael Cheshin of the Supreme Court of Israel and for the Administrative Law Department of Israel's state attorney. Last but not least, we have Natasha Hausdorff. She's a barrister in the UK and legal director for the UK Lawyers for Israel Charitable Trust. Her practice spans civil and commercial litigation, arbitration, regulatory matters, and public international law. After her law degree at Oxford University and an LLM specializing in public international law, she clerked for the president of the Supreme Court of Israel in Jerusalem. She's also been a fellow at Columbia Law School in the National Security Law Program, and she's a frequent contributor on legal matters for international media, including the BBC, Sky News, CNN, Fox, and online publications. So first, thank you all for joining us tonight. To our event. Yesterday, ICC Prosecutor Karim requested that the court issue warrants for the arrest of Hamas leadership, as well as Israeli Prime Minister Benjamin Netanyahu and Defense Minister Yoav Gallant, alleging the commission of crimes against humanity. While Khan's statement has drawn criticism from Israeli allies such as the US, France, and Germany, what happens next remains unclear. So tonight, we're going to take a closer look at what the ICC is, its history with Israel, the implications of yesterday's news for Israel, and what steps are available to Israel and its allies, either before or after the issuance of warrants, as well as what implications, if any, this story has for other Western democracies. Q&A will follow the panel, so you're welcome, starting at almost any point, to put your questions into the Q&A box at the bottom of the Zoom screen, and we will get to them, I hope, in about 40 to 45 minutes. So with that, let us begin. I'd like to start, please, with you, Orde. I want to unpack with you what the ICC is before we get into the substance of the current story, on what authority it functions, how it functions, who's a party and subject to its jurisdiction, how it authorizes prosecutions and gathers evidence, what rulings it can issue, and of course, why the US and Israel are not parties to it. Please.
Thanks. It's a pleasure to be here. So the International Criminal Court was founded about 2 decades ago. It has 124 or so members. It counts Palestine as a member. I don't count Palestine as a member, so it's maybe 123. The members of the International Criminal Court do not include Israel or the United States. The United States and Israel have long refused to join out of concern that what would occur is exactly what has occurred, that the ICC would become politicized and be used as a tool by the lawless against the law-abiding. The United States presidents of both parties have refused to join the ICC. The U.S. has a particular law on the books, which basically it's colloquially known as the Hague Invasion Act, which authorizes the president to use all means necessary to liberate and protect not only any U.S. officials that might get caught up by the ICC, but also officials of U.S. allies that don't recognize the jurisdiction of the ICC. And Israel is specifically listed there in the law. The ICC has a very poor track record. It has spent over $2 billion and has, last I checked, less than 10 substantive convictions of anybody anywhere. With regard to its jurisdiction, there are two principal arguments that Israel and the U.S. make for why they're not subject to its jurisdiction. The ICC treaty, the Rome Statute, provides that for something called complementarity, where if you have a functioning legal system that polices your own personnel that are credibly alleged to have violated the statute, then the ICC has no jurisdiction to go after them. Israel and the U.S. also claim, with good reason, that the ICC has no jurisdiction over them because they are not parties to the ICC. They chose not to join. Nevertheless, here we have the warrants that were issued, the warrants that were applied for. What happens here is that the ICC prosecutor submits warrant applications to the pretrial chamber, which is a group of 3 judges, and then they have a certain period in which they look to see if the threshold is met, and only after they give the green light do the warrants move forward. The specific warrants for Netanyahu and Gallant, the specific warrant applications, rather interestingly enough, they're, so far as I can tell, almost entirely related to accusations of starvation of civilians. The ICC did not apply for warrants based on, shall we say, shooting crimes. There are several reasons for that, including the fact that I think it would more gore the ox of the United States and the UK and others if you go after Western democratic leaders for shooting crimes, because Israel, frankly, has better systems in place for avoiding, violating proportionality and distinction, et cetera, with regard to civilians than the US or UK has. Anyway, that's what they've done. The ICC prosecutor, Karim has gone after, has issued these warrant applications. It's hard to tell exactly when the pretrial chamber will rule. Sometimes it's as quickly as a month. Sometimes it's taken much longer. But that's where things currently stand.
I want to give other panelists a chance to react or to add if they'd like, although that sounded to me like a pretty comprehensive introduction. In the event that you have something to add, please do so. But if not, then I've got. All right, next question. So in light of what we just learned, looks like we may be facing a somewhat complex situation. And this is not the first time that we've had some kind of run-in with the ICC. Avi, can you explain to what extent Israel has already had some ICC history, or at least threatened, lawfare prior to 2021, let's say, and how it played out?
Yeah, so let me just jump back to one thing that Orde said. I think that it was a very, as you said, a very comprehensive overview of what the ICC does and how we got here. But we have to understand that the ICC didn't become politicized. It was created politicized, and these disputes go back all the way to the drafting of the Rome Statute. And one of the things that drove Israel away from signing the Rome Statute was a provision that was drafted specifically in order to try to move international law to criminalize Israel permitting Jews to reside in the disputed West Bank and parts of Jerusalem. And it was clear then already where the ICC was going to go, that it was ultra politicized. The judges themselves are ultra politicized. They're not. It's unfortunate they're not well respected. The most respected, certainly not the most respected in their fields. The prosecutor's office has its problems. This is a body that's always been political. So the problems with Israel. Israel's been on a long-term target for the ICC for many, many, many years. So the PLO started a process of trying to get the ICC to prosecute Israelis all the way back in 2009. Now, there was a problem, as Orde said, that Israel's not a party, and therefore the court doesn't have jurisdiction over Israelis. And so for over the course of 6 years, from 2009, a little bit less than 6 years, between 2009 and 2015, the court cooked up together with the PLO this very shaky theory on jurisdiction over a state of Palestine that could then get Israelis to be defendants. This was done, by the way, with the assistance of a group of pro-Palestinian international lawyers in the world, like William Shabbos. And eventually this came up after a multi-year process. The courts the prosecutor's office started a preliminary investigation against Israeli defendants on the basis of the so-called situation in Palestine in 2015. Now, this went forward several years, and after about 5.5 years of this preliminary investigation, the ICC prosecutor, it was no surprise to anybody but a few people I'll mention in a moment, the ICC prosecutor asked for permission to graduate this to a full investigation. Now, because it was a preliminary investigation, they had to report every year on what they were doing. And so while it was called the situation in Palestine, they were quite frank about the fact that they were looking at primarily, if not exclusively, at Israeli defendants, and they were ignoring all the crimes of the PLO, Fatah, and the Palestinian Authority, and had some vague references to Palestinian armed groups, which we were to understand was not going to include Palestinian terrorists that were working with the ICC. Right? And we get forward to the full investigation, and the investigation has finally produced suggested charges now. Now, where along this process has Israel tried to act? Well, as we were leading up to the closing of the preliminary investigation, Israel had a multi-year process of its best legal authorities and diplomats in the foreign ministry of cooperating with the staff of the ICC prosecutor's office to try to get it to understand that there is no state of Palestine, and the state of Palestine that does not exist does not have any territorial jurisdiction, and therefore it is not possible for the ICC to claim jurisdiction over Israeli defendants. And they had many, 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 many polite discussions, and the Israeli legal teams were very, very certain that they'd convinced Prosecutor Bensouda of the merits of their decision. And then, whoops, it turns out that they'd been fooled, that this was simply a way of showing that Israel had cooperated with the process, not a way of changing any of the decisions. And she said that the ICC had jurisdiction, went to the court, and the court, of course, the pretrial chamber of the court said yes. Now, this wasn't the only one. There was a case where the prosecutor was asked by Comoros to file charges against Israeli soldiers for alleged crimes in boarding a ship that was unlawfully breaking a lawful blockade of the Gaza coast. The name of the ship was the Mavi Marmara, was flagged as a Comoros ship, and therefore they said crimes committed in the boarding of it could be under the jurisdiction of the ICC. The ICC only has jurisdiction over extremely grievous crimes, over crimes of great gravity. And the prosecutor thought that this was a silly case to bring as the first one against Israel. She wanted to close it. She was ordered to reopen it because she didn't understand properly that gravity, when applied to the Jewish state, doesn't mean the same thing as it does anywhere else in the world. It means something different, and so therefore it's very grievous if the Jewish state was involved in it. She made another decision. They shut her down again, and finally, after the third time, they allowed the case to go. This should have told Israelis about how to view the court. It did not. And this gets us to the last thing, and I suppose this I'm going to cue this up to allow Natasha to take this. But after 2021, when the court said that okayed the investigation against Israel and okayed jurisdiction for the court, the prosecutor began a series of push forward charge sheets against Israelis. He threw a lot of smoke in the air about different ways that this was going to be done. He opened up this up again. He asked Israelis to cooperate with them. And once again, the same legal team that had failed with Bensouda took charge and ran forward to talk with Karim Khan, inviting him multiple times to Israel, passing him reams of information, being sure absolutely that this time it was going to work. And lo and behold, it did not. Now, I think that this should tell us everything we need to know about this institution and where we are going. We have to take a different course if we're going to stop this travesty of justice, and relying upon the integrity of the prosecutor's office or the judges in the court is a big mistake.
A lot to discuss there. Or do you have any thoughts on this before I turn to Natasha, who will take us to the current effectively, the current case?
No, I wouldn't have anything to add to that at the moment.
Okay, great. Well, in that case, I think Avi was right. Natasha, he's queued you up. I'm going to ask you to discuss the immediate history of the current investigation and what you think happens next.
Well, thank you. A lot of this comes down to that preliminary determination ruling on jurisdiction from 2021, Pre-Trial Chamber 1 making that decision on a 2-to-1 split, and endorsing, unfortunately, the legal acrobatics that the prosecutor at the time, Fatou Bensouda, engaged in seeking to justify jurisdiction on the basis that the state of Palestine was enough of a state to join the Rome Statute. There are clear criteria set out for statehood, which are internationally accepted under the Montevideo Convention criteria: a defined territory, a permanent population, a government, and a capacity to enter into international relations. And it's not realistically put forward, I don't think, that the Palestinians fulfill those, but alternative arguments, and I have to say novel arguments, were introduced on the question of jurisdiction to the court, which were in part adopted, as to the right of the Palestinians for self-determination, and the fact that it seemed to be the right thing that the court should be allowed to pursue this. Just taking on board some of the factors that Avi has addressed, I think it's really important to recognize the abject failure of the International Court of Criminal Court to live up to the expectations of the international community. It has been under fierce criticism. Most recently, a detailed report in 2020 that criticized the amount of money the court had spent, the woeful track record it had of securing convictions and the focus of the court had been almost exclusively on individuals from African states. All of this has undoubtedly led to the desire to focus on Israel. It's become the world's punching bag, the Jewish state, and therefore an optimum way for the court to seek to rehabilitate itself. So taking into account really what we saw in 2021 and the fact that international law was being thrown out of the window, that an investigation was approved even though the court didn't have jurisdiction, that really set the scene for what we've seen most recently after the 7th of October. We had Karim visiting the region. He spoke both from the Rafah crossing and then later at a press conference in Cairo. And he made some remarkable comments for, I have to say, a fellow member of the English bar, an individual that is incredibly well respected as a criminal practitioner with a long history at the Crown Prosecution Service here in the United Kingdom. He talked about the alleged crimes of Hamas, those that were caught on GoPros by the perpetrators themselves and sent around the world celebrating the atrocities that they had engaged in. And the prosecutor also talked about the need for Israel to prove that what it was doing in Gaza was in compliance with international humanitarian law. I found that shocking. That characterization as an inversion of the burden and standard of proof. And that ought to have been, I have to agree with Professor Bell, an indication of the trajectory of this investigation and perhaps the motivation of the court. These seem to me to be political statements rather than ones that had legal currency. Nonetheless, not only did we see cooperation from the State of Israel, despite the lack of jurisdiction here. But we also very worryingly saw some of the families of the victims of the 7th of October atrocities engaging with the prosecutor, providing witness statements, making complaints to the office of the prosecutor and seeking an investigation into Hamas crimes in the territory of Israel, where the court, again, I reiterate, has no jurisdiction. And the consequence of that we saw yesterday, with the approach of the prosecutor seeking to appear apparently even-handed, this very English approach of both sides, in a situation where I have to say it is utterly morally repugnant to draw any form of equivalence between these medieval terrorists who have plainly rejoiced in the atrocities they have committed, as against the democratically elected and accountable individuals that have formed the target of arrest warrant applications at this juncture, the Prime Minister Benjamin Netanyahu and Yoav Gallant. I mean, apart from anything, there are, I would say, two fundamental problems with the seeking of arrest warrants against Israelis. If you set aside the problem of jurisdiction, the first is the question of whether this case is admissible, considering the very important qualification which Orde referenced of complementarity under Article 17 of the Rome Statute, in a state where law and order apply, where the rule of law is upheld, and where there would be an ability and willingness of Israeli courts to hold to account anyone who had, in fact, any credible allegation against them, then such a request for arrest warrants ought not to get off the ground. But the other added aspect here is when we consider the conditions that apply under Article 58 of the Rome Statute, the reasons for requesting an arrest warrant also don't apply. There needs to be some sort of necessity to bring those individuals into custody to either facilitate the investigation and prosecution or to prevent crimes from being continued, to name but a few. And there's no sensible, reasonable explanation that can support an application when you see it in the context of the requirements or the conditions that apply under Article 58. Again, I think it leads us with the only conclusion that can possibly be drawn, that this is a political stunt. And the final aspect of this I would refer to is the prosecutor's attempt to provide himself cover with the expert report, which was also published yesterday. A panel of some celebrity lawyers, many of whom have a track record of bias against Israel, that was put forth in very robust terms in an article today by the preeminent legal journalist Joshua Rosenberg, who picked out in particular the comments by Friedman, barrister, King's Counsel here, and also Baroness Kennedy, who have made repeated comments even after the 7th of October, which would in any other context have ruled them out entirely of being considered impartial in this respect. These are just some of the individuals that the prosecutor has relied upon to rubber stamp his application of arrest warrants. And again, it leads us with the only real conclusion here, which is that the origins of the court, and Avi picked out the drafting of the Rome Statute and how this had been already designed in order to generate new international law to criminalize the practice of Jews moving to Judea and Samaria of their own volition, as an expression of their own free will, essentially to suggest that there was criminality attached to Jews living in certain areas simply because they are Jews. That was the situation when the court was formed, and that it is ultimately and inevitably, one might think, led to the political position that was put forward yesterday in the application for these warrants is unfortunately not surprising.
So just a quick question that I've seen in the audience. I normally wait till the end for this, but I think it's worth mentioning. There's a question as to what the specific charges that have been brought are or alleged.
Well, I'm looking at the prosecutor's statement, and as far as the Hamas individuals, Yahya Sinwar, Ismail Haniyeh, and Mohammed Daif are concerned, it's extermination as a crime against humanity, murder as a crime against humanity, taking hostages as a war crime, rape and other acts of sexual violence as crimes against humanity, torture as a crime against humanity, other inhuman acts as a crime against humanity, cruel treatment as a war crime, and outrages upon personal dignity as a war crime. With respect to the Israelis, Benjamin Netanyahu and Yoav Gallant, Orde mentioned starvation of civilians as a method of warfare. There are also their additional crimes included in the prosecutor's statement, willfully causing great suffering or serious injury to body or health, willful killing, intentionally directing attacks against a civilian population, extermination and or murder, persecution as a crime against humanity, and other inhumane acts as crimes against humanity. So while starvation has certainly been at the center of many of the public statements, and I believe also the interview that Prosecutor Khan gave, there are clear indications that he is alleging the targeting of civilians. And given that both the UK and the US have been, I would say in some respects, surprisingly robust, given the other rhetoric we've heard from both of the respective foreign officers, that they have been surprisingly robust in outlining Israel's adherence to international humanitarian law, and at the very basic level that Israel does not target civilians. It's even more shocking and concerning that the prosecutor would be making these unfounded and utterly ludicrous allegations.
So
I want to move the conversation forward to the question of what.
So
Of
let
course,
me
yes.
just add one thing, and then Avi. As always, I must say I'm in awe of Natasha, who both has such substantive knowledge and is so eloquent in present. And I recommend everybody, do as I do and watch Natasha's videos and other things. I mean, really astonishing, tremendous asset to the pro-Israel cause. One thing I would say, and this is something that I and some other analysts are sort of looking at, and this is sort of a minor thing, which doesn't in any way contradict any of what Natasha said, but it looks like all of the crimes alleged against Netanyahu and Gallant are in the context of furthering the starvation. Now, to what degree, you know, why is he doing that? Again, I think he's trying to avoid bumping up against the UK and US, but I think they, as I'll describe in a moment, the US and certainly is going to go after Khan hard in response to these warrant applications, regardless. Avi?
Yeah, I'm sure we're going to get to all those things later. I just wanted to add two small things related to these comments. We have to understand about Karim Khan and what he is doing. So one of the things is that previously, before Khan, there was a general consensus within the prosecutor's office and of the court to follow a general prosecutor's rule of not bringing charges unless there was a reasonable prospect of success before the court. Karim Khan has clearly abandoned that, and it's not just in this case. You know, the announced charges against Russian leaders was also clearly just a political stunt. In this case, it's fairly clear that the charges against the terrorists, Mohammed Dev, Yahya Sinwar, and Ismail Haniyeh, are intended fig leaves for the proposed charges against the Israeli leaders. And the charges against the Israeli leaders are so beyond any reasonable theory that they could prove in court, both in the bizarre interpretation of the relevant law and in the absolute absence of any evidence to prove these claims. It's fairly clear that they don't expect ever these things to get into court. Now, of course, no Israeli leader would be foolish enough to show up and be the Alfred Dreyfus in an ICC courtroom in Hague. So he's moved to political stunts as a way of trying to rescue the ICC from extinction, and this is a very, very bad and troubling development. Now, the other thing, this is even briefer, is Khan put out a tweet about a week and a half ago, and we should pay attention to it, in which he put out a statement which he basically threatened under Article 70 of the Rome Statute to put in jail anyone who criticizes or tries to block the unlawful prosecutions of the court. And this is mafioso behavior. This is an attempt to influence, to intimidate, to extort behavior from elected leaders in Israel, in the United States, in Britain, to conform to the behavior that he wants for his political stunt. This is unbelievable behavior. It's clearly criminal. And we can talk about this later, but it is really, really important that Khan not be permitted to get away with this kind of crime boss behavior.
Perfect transition, I think, to the next, well, somewhat perfect transition to the next question, which is effectively what steps remain now to Israel and to its allies, with a view again to the idea that, you know, perhaps this series of events is not just meaningful for Israel, but of course for the West more broadly. And for that, I'm going to turn to all three of you. So we'll start with Orde, and then Avi and Natasha. And if you feel comfortable, you can pretend you're actually representing the country in which you live. So go for it.
So yeah, thanks. I will I'll focus on the US perspective. There's a clear perception in Washington that the ICC warrant applications for Israeli leaders threaten US national security. As I mentioned, since the ICC's founding, every US administration of both parties has refused to join the court, fearing exactly what has happened. The ICC's proposed warrants for Israeli officials would set a dangerous precedent for US officials The ICC happens to have an open investigation of alleged U.S. war crimes relating to Afghanistan, which the court placed on the back burner in 2021. There is concern that the precedent set vis-a-vis Israeli officials could be used to turn around and go after U.S. officials. And the military community in the United States is particularly concerned about this. The military coalition represents more than 5.5 million current and former U.S. service members, and I've been in dialogue with them, and they have warned that the Afghanistan investigation by the ICC could lead to the arrest, prosecution, and detention of American military personnel and veterans in foreign countries. So it's important to understand that is part of the U.S. motivation here is supporting Israel, and part of the U.S. motivation here is, frankly, avoiding setting precedents that will be problematic for the United States. So the United States has basically 4 moves it can make, it seems to me, with regard to responding to the ICC. One, as I mentioned, there's the American Service Members Protection Act, enacted in 2002, which restricts U.S. cooperation with the ICC, provides the president authorized to use all means necessary and appropriate to bring about the release of any person described. The described persons include officials of Israel. The U.S. has that move available to it. I don't see the Biden administration, sending troops into The Hague anytime soon. But this act sets the framework for how the U.S. Thinks about things. The act also restricts U.S. cooperation with the ICC. Now, the U.S. Under the Biden administration has edged towards the line and probably across the line with regard to U.S. cooperation with the ICC. This was principally driven, I would say, by the U.S. Effort or interest in holding Putin accountable for what he's doing in Ukraine. Folks in Washington thought, I think mistakenly, that the ICC would be useful in pushing back against Putin. I think it's not particularly useful. But what happened is that during the Biden administration, so it's important, the U.S. Is not a member of the ICC, so we don't provide funding to the ICC. So we can't pull funding from the ICC, although I'll get to that sort of in a moment. But the U.S. does provide various types of intelligence and other practical assistance, which are crucial to the ICC's ability to operate successfully. The ICC's limited successes, the less than 10 successful prosecutions that I mentioned, many of them have relied on U.S. assistance. And so when rumors began to emerge a few weeks ago that Khan was going to issue arrest warrants for Israeli officials, there were 2 main threats that members of Congress made to Khan. One is, we will impose sanctions and visa bans on you, which I'll describe in a moment. And the other is, we will halt all U.S. cooperation with the ICC. And that actually, comes with a cost to the ICC's ability to operate. Even a bigger cost on the ICC's ability to operate would, of course, be the U.S. imposing financial sanctions and visa bans on Khan. Avi, I think it was mentioned, Fatou Bensouda, Khan's a predecessor who aggressively pursued politicized investigations of the U.S. and Israel for alleged war crimes. The Trump administration had responded by imposing sanctions on Bensouda and one of her aides. These sanctions had a bite. According to Reuters, Bensouda, who lived in the Netherlands, abruptly found her bank accounts frozen and credit cards canceled as a result of the U.S. Financial sanctions. The Biden administration then lifted those sanctions in April 2021. Now, there are 2 bills pending in Congress that would force the president's hand. The president obviously has the ability on his own to impose these sanctions on Khan if he wants to, under the authority of the International Emergency Economic Powers Act. Whether he will or won't, I think he probably won't on his own. But there are two bills pending in Congress, which I helped draft, which would impose financial sanctions and visa bans on ICC officials who investigate or prosecute troops and officials of the U.S. or of its allies. The Senate version has been in place for a year. Senator Tom Cotton, along with Senators Ted Cruz and Marco Rubio, introduced it. There's a House counterpart, which was introduced by Representatives Chip Roy and Brian Mast recently. I think that there's a strong possibility that such legislation will pass in Congress. And it's powered by two things. First of all, Congress is just upset that the ICC is doing this and would be in any event. But the dialogue between Congress and Khan after the rumors emerged that Khan would go after Israeli officials have significantly, in my view, fanned anger in Congress. Basically, as has been reported, Lindsey Graham himself said so in a tweet. The members of Congress, there was a letter, 12 senators led by Tom Cotton, threatening sanctions on Khan after the rumors emerged. I helped draft that letter. And then there was also a meeting in which bipartisan members, 8 bipartisan members of Congress, told Khan that if you do this, we will impose sanctions on you and end all cooperation. And in response to those threats, it was the understanding of Lindsey Graham and others, and I'm not telling anything out of school, this was reflected in Lindsey's tweet. It was their understanding that Khan was backing off and negotiating a deal with the Israelis. And according to press reports, the deal was in the process of being implemented. Khan was scheduled to visit the U.S. His people, Tom Lynch, his chief of staff, was about to take off and head to Israel. But Khan all of a sudden turned around and moved these warrants forward, went on Christiane Amanpour, did this oral presentation. And it's important to understand that betrayal of members of Congress. Some of us heard from Lindsey Graham before Khan did this. If Khan moves ahead under these circumstances, Graham will be even madder than he would be otherwise. So it's an important story, this betrayal, because it really fuels a lot of the anger by members of Congress. They don't like it when people like Khan do bad things. They especially don't like it when they feel lied to by Khan. And Lindsey Graham's tweet says specifically that. So I think that Congress is likely, certainly the House, I think, is going to pass the financial sanctions and visa ban on Khan and some of his staff. Speaking of Khan's staff, you saw that Khan made a statement announcing moving the arrest warrants forward. He had 2 staffers standing next to him, Andrew Cayley and Brenda Hollis. Andrew Cayley was formerly a top UK legal official. Brenda Hollis was previously a top US legal official. I think that if you look carefully at them, they look very, very uncomfortable. And I would say that watch that space. I think when a prosecutor takes action over the strong objections of his deputies, sometimes those deputies find ways of pushing back. That's all I'll say on that front. With regard to the final weapon that the U.S. has. That has to do with the fact that the ICC is largely funded by key U.S. allies, right? So 2/3 of the ICC's 127 million euro budget is provided by the following close U.S. allies. And I'm going to mention the numbers because they're important. 127 million euro budget. Japan contributes 25 million euros. Germany, 18 million euros. Right there, that is 1/3 of the budget, just those two countries. Then it's followed by France, 13 million euros, UK, 13 million euros, Italy, 9 million euros, South Korea, 8 million euros. These countries all rely on US troops to defend them from the increasingly aggressive Russian and Chinese governments. Do these close US allies really want to endanger the US troops which defend them by funding the ICC's legally and factually baseless, politically driven proceedings against Israel? Put to a choice between funding the ICC and continued support from the US, I think there's only one way that those countries can possibly decide to go. So watch that space. That's my overview of from the perspective of the U.S. government.
We'll move now
Okay.
to Avi and Natasha. We did have a few more questions lined up, but this will be the final question from me out of respect for the time of the audience, which is not to say that anybody here has run long. You could easily speak for hours, each of you, and I think it would be well worth it. So I thank you. So we're gonna go to Avi and to Natasha to wrap this question up, and then we'll move to the Q&A. And as a reminder, if you have a question and then, it's just like sitting with you, put it into the Q&A box and we'll try to get to at least some of what's there, although it's quite populated now.
All right. I will try to make this compressed. I have 5 suggestions for what Israel has to do, and a couple suggestions what it must stop doing or never do. All right. So let's start with the first. The first one is rather obvious, and the foreign ministry has already announced that it's intending to do this, which is a campaign of public diplomacy to work with Israeli allies, democratic liberal states around the world, to try to get them to, those that are in the ICC, to withdraw from the ICC, those that fund the ICC to stop funding the ICC, and to engage in a lot of the actions that I'm about to suggest that Israel engage in. This is, it's unfortunate that this hasn't been done as seriously as it ought to be until today, and I hold limited hopes at this point for a campaign on the Israeli front. I think that should the White House decide to throw its weight behind such a campaign, would have a lot more success. I'm skeptical that this White House will do that. All right, number 2. Israel has to have an aggressive campaign of non-cooperation. It is a fact that refusing cooperation, blocking cooperation with the ICC has been successful for some countries, not just for countries that are superpowers like the United States, which was very successful after putting sanctions on Bensouda and getting the ICC to reconsider its political campaign against American service members, but also countries that are smaller. Countries like Kenya have had success in through non-cooperation. By non-cooperation, I don't mean just refusing to invite Khan for visits to Israel. And again, I can't understand how any Israeli could have agreed to do that. Nor passing along documents, which again, I can't understand why Israel has done these things. But I'm talking about more aggressively, those who cooperate within the government must be stopped from doing so. Even private citizens, to the extent that we're talking about interfering with foreign policy of Israel against Israeli interests, it's already on the books as a crime. Privateering on foreign policies on the crimes is a crime in many many, many states. And this is one that has to be handled with care in order not to exceed the bounds of proper behavior for a liberal democratic state. But Israel could certainly use legislation of the American kind, the American Service Members Protection Act, which Orde said accurately is referred to colloquially as the Hague Invasion Act, and other legislation, which I know has been kicking around in the Knesset for some years. It's long past time to adopt it. Number three is sanctions against personnel. Orde mentioned the basics: sanctioning bank accounts, sanctioning, refusing visas. I think that this is obvious and needs to be done. It's also obvious, by the way, that Israel's ability to play this game is much more limited than a country like the United States or even the UK. Number four is criminal charges against personnel of the ICC prosecutor's office and even the ICC itself. I would not do this recklessly. I would do this for the real crimes that they are committing. At the moment, what they are threatening, they're carrying out extortion by threat and threatening improper and unlawful legal procedures. They're threatening international kidnapping. They're threatening to take into custody people they have no jurisdiction over. And arguably they're engaging in not just material support for terrorist organizations, but actively cooperating with Palestinian terrorists in cooking up these false charges against Israel. Now, all these are quite reasonable grounds for criminal charges, certainly much more justifiable grounds than any of the things that the ICC prosecutor's office has issued. And it's time to actually start pushing some of these forward and exploring whether there's room for putting these people on trial. And finally, the fifth one that should be done, this one strikes me as remarkable that it hasn't happened, and I'm not the first person to note this. There's legislation in the United States that sanctions the PLO should it take a move to initiate criminal charges against Israel in international courts. And the PLO did this more than at this point about 15 years ago, and the threat of sanctions was never carried out. And at this point, of course, it's pointless because the ICC prosecutor acts on its own. The PLO did all that it had to do when it gave the authorization, when it joined the treaty as the so-called state of Palestine. But it's not too late here, and it's particularly because the ICC prosecutor's theory of why he's able to bring up Israelis on charges of non-crimes is because he has jurisdiction over the situation in Palestine, because he says there's a state of Palestine. And if the state of Palestine withdraws its withdraws its participation in the treaty, there goes the ICC prosecutor's excuse. Now, what are the chances of it? They're not great, but let me tell you that the PLO is vulnerable to pressure, especially pressure from the United States. It is an economic basket case. Besides being highly staffed with terrorists and funding terrorist organizations, it has very few independent sources of funding other than the Swiss bank accounts. And that means that if serious sanctions are put on the PLO and the PA, it's very difficult to see them proceeding in this reckless course of lawfare. Now, I'll just say very briefly then the two things that Israel must absolutely stop doing and not do. Okay, number one is it would be a big mistake for Israel to engage in any more legal argumentation before the court that gives the court legitimacy as if it engages in legal processes, which at least with regards to Israel, it is not. All it is doing is political theater, and it is using legal rhetoric in order to try to dress this up. Israel's already played this game once. It made the mistake of indirectly submitting arguments regarding jurisdiction, which were completely brushed aside by the court and by the prosecutor. There is no need whatsoever to engage in this again, which brings me to the second one. It is a big mistake to engage in any way or fashion with the ICC behind the scenes, in front of the scenes to negotiate, to pass along information, to try to speak with them as if they're reasonable people. What you can see by the story that Orde told is, and accurately, by the way, about behind the scenes contacts to try to reach a deal. This is not the first time that it's happened, by the way. Is that the interest of the court in such things is to throw smoke, to distract, while it engages in unlawful and unethical behavior behind the scenes, and also afterwards, in order to make a false argument that it's everything that it's doing is objective and carefully thought out and relying upon evidence. There is no reason to give them this smokescreen. There's absolutely no reason to give them the opportunity to polish the lies that they're going to tell in their process. Fooled me once, shame on you. Fooled me twice, shame on me.
Okay. We have in fact run long. So Natasha,
Yeah,
as the person
I'll keep
with
it
the best accent on this call.
I'm not sure about that, but I would just, at the risk of stating the obvious, caveat everything so far, and just with this, that Professor Kittrie, Professor Bell, and myself, as upholders of the rule of law, would certainly not have been making any of these suggestions had the court been in fact applying international law, acting within its jurisdictional limits on the basis of the Rome Statute, which set up this court. But I think all of these suggestions are legitimately put forward in regard to a court that has very badly lost its way and is in fact abusing international law for political purposes. And with that, of course, the UK, as the member of the International Court of Criminal Court, a signatory to the Rome Statute, notably does have particular sway. And I think if it were to take a particular position, could have a significant degree of influence, despite the fact that an international court is supposed to be independent. Again, that is very relevant where the approaches of an international legal institution have plainly gone off of the rails. I think the real problem is that the matter has become a partisan issue. And you can see this from the reactions today, the difference between that of the Prime Minister. Rishi Sunak gave a very short statement where he said there is no moral equivalence between a democratic state exercising its lawful right to self-defense and the terrorist group Hamas. It is wrong to conflate and equivocate between those two different entities. I'm sure it could have been much stronger, but still a statement that highlighted concern with the prosecutor's approach. If you contrast that with the position taken by the shadow foreign minister, David Lammy, and if you are to believe polls, most likely to be the future foreign minister, the position taken by Labour as a whole is that it supports the independence of international courts and the prosecutor's application for warrants, as well as the ICC's jurisdiction, as a matter for the ICC. But I would very strongly advocate that there are UK interests at stake here as a member of the Rome Treaty. If this court is in fact acting out with its jurisdiction and pursuing a political agenda, because it is law-abiding states that stand to be the targets of political attacks of this nature, because they are the ones to take this court more seriously and to seek to abide by international law more generally. We've already discussed the lack of impact that the court's approach to Putin in particular, vis-a-vis Russian potential defendants, has not been particularly effective at all. I would only add that I have just today come back from Australia, and in my time there, I had marathon meetings with many politicians where the ICC was a topic of conversation, of course, even before these warrants were applied for. And I am encouraged that a number of senators in Australia, it's also a party to the Rome Statute, had also written in similar terms to Prosecutor Karim, highlighting their serious concerns with the approach that was being taken vis-a-vis the investigation. And one can only hope that those concerns will be reflected now across a broader part of the political spectrum in Australia. Unfortunately, the party, the Labour Party, hasn't been particularly mindful, I would say, so far, it seems, of the lawfare agenda against Israel. In particular, its vote at the last General Assembly resolution indicates that that the government itself may not necessarily be following the very sensible recommendations of Orde and of Avi. But there is certainly more that states such as Australia, such as the UK, as members of the court, are in a position to do. I can't say that I'm holding my breath to see significant action there. I think it's bound to come more robustly and more significantly from the United States, and as I hope from Israel also.
So, first of all, thank you for what I think has been a fascinating presentation. I am going to ask some audience questions, although I know that we've hit the hour mark and people have to leave. So we'll continue for about another 10 minutes. As I said, we really want to respect people's time. And to the extent that we can, I'm going to try to merge some of the questions that I've been reading as we've been speaking. Okay. So there's a question that arises as to the credibility of the ICC institution. There are a couple of questions actually on either side of this. One, which is, has the ICC effectively shot itself in the foot, or are we kind of in a bubble right now speaking to ourselves? Is this a patently clear violation that will effectively lead to the institution being considered broadly illegitimate? And the kind of other side of that is that despite what we're saying, the ICC is being reported on as a legitimate judicial institution and as a legal voice. And people are wondering, in what way they can challenge the credibility that at the very least is being conveyed by the media. So who wants to jump in?
I can say something. Oh, no, go ahead, Orde. Okay.
No, just go ahead.
Okay, Orde.
All right, thank you. No, I just say, look, I mean, in terms of the credibility of the ICC, I can speak from the perspective of the United States and Washington. I would say that sitting here, it looks like the ICC has indeed shot itself in the foot. 2 months ago, the ICC enjoyed a very cordial relationship with the Biden administration. The Biden administration was providing them with all kinds of data and information to be used against Putin in other cases. The U.S. has the ability to, sometimes say, oh, look, so-and-so suspect is over here. Why don't you ask so-and-so to arrest them, right? I mean, all of this is very valuable to the ICC, and there were no sanctions in place on the ICC. But right now, with regard to the U.S. Is furious. And it's not only Republicans, but also many Democrats. Biden said what the ICC did was outrageous, and I've been watching carefully what members of Congress are saying. And there are a number of important centrist members of Congress who are hammering the ICC for this. And I think the ICC is going to pay a price in the United States. For sure, any cooperation it receives from the United States is over. That is clear. What are the chances that sanctions are imposed on the ICC? I think they're quite strong, actually. I think legislation is quite likely to pass, and I don't think Biden's going to veto it. And the U.S. is going to be very motivated to pressure those allies I mentioned who fund the ICC to use their leverage. So I think with regard to the United States, the ICC has indeed shot itself in the foot. In terms of what people can do, I think, obviously, if you're an American, you can write to your member of Congress. If you live in the UK, you can write to your member of parliament. I would say that there are relatively few people who, like Avi, Natasha, and I, are out there on a day-to-day basis laying out the arguments for why what the ICC is doing is wrong. And I would recommend that other people, attorneys, but also non-attorneys, should be taking note of what we say and echoing those arguments in Twitter and op-eds, et cetera, One thing that I would sort of reiterate, which I alluded to briefly, is that the military establishment in the United States, I think probably also the UK and Australia, is very concerned about what the ICC is doing to Israeli officials. So if you want to know who your allies are, it's, like I mentioned, US veterans and serving officials and retired JAGs and current JAGs, Judge Advocate Generals, military lawyers. So those are potential allies who should definitely be reached out to. Avi.
Yeah. So I lost my train of thought here. So the court is, I think, very clearly misbehaving. I think that when we look back in history, we're going to look at this as the moment. This is sort of the League of Nations during the 1930s. This is the moment when you have an institution that has fine rhetoric and was looked at as perhaps something that one day might become effective. To do something good will clearly never become that. Karim Khan has gone beyond that. Instead, is in order to try to show that the court is doing something, it was previously seen as completely ineffective and not acting against the world's worst criminals. Instead, he's turned it into a political clown, where it goes after high-profile targets in order to get into the newspapers without any prospect of success, and in some cases, quite immorally. Now, if you're thinking about how to deal with this, you should think that there are two different ways depending on where you stand on the ICC. I happen to have always been a critic of the ICC. I've always been skeptical about it, and I would be perfectly happy to see the ICC go in the direction of its suicide, which is what it's committing right now. There are others, though, who have always thought that the ICC had more promise than that, and who do look at the ICC as doing something positive. The way to see this is think about an ordinary court of law in Alabama in 1910, where it's very good at certain kinds of disputes. But if a black man is charged with killing a white woman, it's very clear what the outcome is, and it doesn't make a difference how good they are on contract disputes. And if you think that that's what the ICC is, that it's capable of doing good on other disputes, but on this one, it's hopelessly biased and terrorist supporting and disingenuous and dishonest, then you should be pushing all the harder for the ICC to drop this direction. And then there's the very last thing. Let's understand that the way this case is made up is the way that all the cases are made up against Israel in the UN, the ICJ, and all these various organizations. And it's based on three different elements. Now, one of them is the attribution of evil motive to Jews, right? And you can't do anything about this because it's unprovable and undisprovable. It's saying that the Jewish leaders intend to starve Palestinians, even though it's completely false. How do you prove what's in anyone's mind? So one of those false attribution of motive. Number two is false statements of fact. Now, this intent to starve that's been going on allegedly for a half a year doesn't somehow or another doesn't actually seem to prove to result in anybody starving. But there's a whole machine by which these stories and narratives are put together, in which there's evil things that are done by Jews, which again don't ever get proved. And then there's the last thing is wrapping the law around these distortions, where the ICC creates the law that if Israel abides by the rule of humanitarian supplies in war, but we attribute to it false motives, and we say that starvation is imminent, then all of a sudden the law makes this a crime. And this identifying the way that these cases are put together is key, because the ICC is not the only one. You have to take this knowledge and move it elsewhere. You have to use it to evaluate the anti-Israel claims of the UN, of the ICJ, and others.
Those are two extremely comprehensive answers. The only aspect I would seek to add is to encourage people to look at the facts. And when I look at the most recent COGAT update as to the humanitarian initiatives, and this is in the context of this obscene allegation of intentional starvation, the total number of trucks that have gone into Gaza, with Israel facilitating that, is 29,746. That's 572,300 tons of humanitarian aid. The majority is food, and the analysis I've seen along the way from the World Food Organization is that this is multiple factors of what they estimate the humanitarian need is for the provision of food for the entire population of the Gaza Strip. It's certainly well documented that that aid is being diverted by Hamas, stolen by Hamas. So whether or not it's reaching the civilians that need it, I think there can be legitimately a question mark over that. But Israel's contribution to this humanitarian aid initiative and facilitation of that aid is a matter of public record. And people need to arm themselves with the facts in order to, I think, follow the very sound advice of Avi and Orde in combating the misinformation, not just at the ICC, but across all of the international legal institutions that are being abused as part of this political campaign against Israel.
On that note, I'll do moderator's privilege and finish with one last question. I think it's worth restating what the law is on the provision of humanitarian aid during warfare. And for that, Natasha, if you feel comfortable, you're welcome to do it, or either of our other two experts. But it sounds from a lot of what you've all said that the law itself is not being applied. So what is it?
Well, under Article 23 of the Fourth Geneva Convention, there is a requirement to facilitate aid in this context. However, it is caveated so that that requirement essentially doesn't apply where there is a fear that that aid is being diverted. Now, there is clear evidence of diversion by Hamas, by humanitarian NGOs, by other states that have been monitoring the situation, and by Israel. Even Fatah has officially declared that Hamas are not just stealing aid, but also shooting aid workers in order to generate a humanitarian crisis. In that situation, it appears to me that the requirements of Article 23 do not apply. They are in fact caveated, and nonetheless, Israel is, as usual, going above the requirements of international law and continuing to facilitate aid in these circumstances.
Can I add two things? Number one, it's not. There's another reason why it's questionable whether Israel is required. Perhaps it's not even permitted to pass along aid in this case, and it's because the Gaza Strip is under the rule of a terrorist organization, and there's international law regarding providing material support to a terrorist organization. And so when Israel passes along humanitarian aid to the Gaza Strip, knowing that it will be diverted to Hamas, it is providing support to the terrorist organization, and that's unlawful. Now, I would say, in Israel's favor, that it does have the excuse that it's doing so under extortion, and perhaps giving something under extortion is not support that's punishable in the way it would be that, for example, Qatar is giving aid to Hamas, but there's strong reasons why Israel should not be providing and should not be facilitating, but it is anyway. But then we get to the second part of this, and this is the second addition, is let's understand that the rule does not say that if you don't facilitate properly, then you've committed the war crime of starvation. Or if you've not facilitated properly, then that constitutes targeting the civilian population as such and a war crime of distinction. These are completely made up, right? There's no reason to connect one with the other. The reason I think that the ICC is doing this is connecting the two, taking what it claims is a violation, falsely claiming is a violation of the rules on humanitarian provision and turning it into other war crimes, is to try to twist this into something over which they have jurisdiction. They don't have jurisdiction over the rules of facilitating humanitarian aid. And second of all, they're taking advantage of Israel's naivete. Israel has naively gone along with the efforts to provide humanitarian aid, even though the law is clear that Israel does not have to. And in doing so, Israel's feeding this narrative as if it is responsible for the plight of Gaza civilians that is created wholly by the misdeeds of Hamas. Israel, by being naive and trying to help them, is inadvertently facilitating the blood libels by people like Karim Khan.
I think it's strong not to conclude on. Again, I want to thank all of our speakers. It's really, really tremendous conversation. I'd like to thank those that joined us. In answer to some of the questions we've gotten, yes, there will be a recording and we will circulate it to anybody who registered for this event. And I encourage you to, as Orde was saying, watch this space for future such events. I hope we won't need to reconvene the panel, but I'm sure we will. And that's it. Good night from Jerusalem.